Hello and welcome to today's webinar. This is Ben Bange from Wessing. We're delighted to welcome you to today's webinar, which is part of our webinar program looking at all aspects and different aspects of data protection and global data privacy issues. So today's webinar will be focusing on GDPR case studies. So GDPR is very much the topic of the moment for many people, many organizations struggling and dealing with different aspects of GDPR, whether it's readiness, whether it's testing, whether it's trying to mature some of your early efforts on GDPR. So today what we thought we'd do is bring you a range of case studies, and there's 4 different areas that we're going to focus on in particular. So a slight change to the way in which we usually present our topics to you. So today we're going to be taking more of a case study approach to these particular topics that you're seeing on the screen now. But before we go on to that, just a few more introductory words from me. And for those of you who are not familiar with Wessing, we are an international law firm, and as you can see from the slide in front of you, we have 33 offices in 20 countries. And today's webinar is brought to you by the International Data Protection Practice here at Wessing. And I head the data protection practice here in London. I also lead and coordinate our global data protection practice. And it's through this practice that we bring you our webinars as a regular feature of our data protection content, which many of you, I'm sure, are very familiar with. And also, you may be familiar because you perhaps registered for the content through the Global Data Hub. And again, for those of you who are perhaps not so familiar with the Global Data Hub, this is our site, our microsite, where we place all things data protection and all things privacy. So our regular news that we bring you on data protection, which is a weekly broadcast of news, that comes through to you and is also accessible separately if you want to register for that. And that's where we try and cut through the noise of data protection and just bring you the relevant topical areas of data protection for that particular week. Also through the Global Data Hub, you can access and sign up for webinars, as you've done today, and also sign up for our regular release of content. And content ranges from more practical content and checklists and guidelines and guidance, for example, through to more thought leadership style content that we publish all around the area of global data privacy. And obviously a big part of that at the moment is focusing quite heavily on GDPR, given the impending deadline that's approaching. And in addition to the content that I've just mentioned, obviously through the Global Data Hub, you can also access the variety of tools that we have available. And just as an example, we mentioned the Global Data Protection Guide, which is a tool that is available for anyone that wishes to use it, that provides for an over 65 country view of different data protection regimes. And we split this down by a defined question set, starting from is there a data protection law, through to more specific questions. For example, do you need a data protection officer? Is there a breach requirement in terms of reporting, and so on and so forth. So to allow you to take that at-a-glance view of those requirements. Feedback that we get is that this sort of tool is absolutely invaluable if you want that at-a-glance view, either by country or by specific question, or if you wish to dissect this by country and by question, and then you could export the results and take them away to use as you wish in your own internal needs. So that's there for anyone that wishes to use it, and do stay in tune with that, because we are updating this on a regular basis, and soon we'll be updating this in terms of, for example, the European view on data protection and how that's changing under GDPR. So soon we'll be updating the map as it is in terms of GDPR implementation and how that looks member state by member state, so you can keep up to date from that local implementation law basis. So the presenters for today, as I mentioned, my name is Vin Vange, and I head the data protection team here based in London. And many of you have heard me speak on these webinars before, so more details about me are there on the screen and on the slides that you'll have for your reference. More importantly than me chairing and hosting the session today, I'm delighted that we've got 4 members of the team. So it's very much a team effort here, looking at the different aspects that I mentioned a moment ago. So in a moment, when we make a start, Sally Anaro, who's a senior data protection advisor in the team here, will be looking at some of the case study aspects concerning consent. Delighted also that we're joined by Jane Reeves, who's a senior data protection counsel in the team here as well. And Jane will be looking at some case study scenarios and questions around GDPR audits and helping work through some of those aspects that are becoming a little bit trickier, certainly in terms of how to approach and how to accelerate the work that you're doing in terms of GDPR audits. One area of organizations which is almost inevitably data rich is HR, or talent, or people, however you describe it within your organization. And our next speaker, as I list on the slide in front of you, is Stephanie Creed. And Steph has a bit of a dual role in that she's an employment and labour counsel here at Taylor Wessing, but also has a very particular focus on data privacy and therefore GDPR impact on the employment and workforce environment. So there we'll be taking a look at that broader issue of HR data and introducing some case studies in that regard. And then we'll finish up looking at data protection impact assessments. And to help us with that particular session, Jean-David Belot, who is an associate again in our dedicated data privacy team, will be walking us through some of the challenges and the data protection impact assessments as we present that particular scenario through to you. So that is the agenda which I've just outlined for you, and moving on beyond the introduction and the case studies and the speakers that I've already presented to you. And before we make a start on that, in the usual way, I will just let you know that at the end we will also have just a couple of polling questions. Again, the feedback that we constantly get is that people want to know what other attendees are thinking and what they can glean in terms of aggregate views around readiness for GDPR. So we'll just poll a couple of questions there to gauge your views, and we'll give you that result before the end of the webinar as well. That'll be a little bit later. Naturally, and as always, if you have questions as we're going along, please do use the question facility, and we will, time permitting, pick up on your questions at the end of the webinar. So, to make a start, the first topic that we're going to look at is the one of consent. And so, just to introduce this in terms of a scenario, we have a scenario that we wanted to use as a backdrop for some of the issues that we see as far as consent is concerned. So take for a moment the following scenario. You have a role where, for example, you are the operations manager and also the data protection compliance lead. The company that you are employed by is Widget Retail, an international widget trading business. Quite a decent sized workforce, 500 employees. And when you think about your basis for processing employee data, the way in which you've approached that to date has been through consent that's been obtained in employment contracts. The purposes around that consent has been based on what you would traditionally find, so paying salaries and salary-related activity, for example, deducting tax contributions, training, development, aspects of monitoring in the workforce, and also dealing with the usual range of HR, talent, and people issues during employment, such as disciplinary matters. So perhaps not that unusual in the scenario itself, but we are finding that the issue around consent and HR and the employment context, and also more generally, is throwing up quite a few particular issues. So historically, consent has been seen as an area where you would you would rely as the basis because it's there in your contracts. So Sally, do you think that's the way forward in terms of GDPR and what that frames consent?
Well, I'd like to say yes, but I'm afraid it's not as simple as that. Consent, as you say, is been traditionally seen as that kind of go-to default basis for employers when they're seeking to legitimize their processing of personal data. It's certainly been heavily relied upon in employment contracts, for example. But the concept of consent isn't as simple as it may appear. Consent has many facets under the GDPR, all of which would need to be met in order for a consent that was collected to be valid. I mean, if we look at the definition of consent, it's any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by statement or by clear affirmative action, signifies agreement to the processing of personal data relating to him or her. So with that in mind, you can see already that consent, if we particularly look at freely given, could be problematic here for this particular scenario. When we think about freely given consent, we're talking about a consent that means that there's a real choice and a control on the part of the individual in relation to their data. It also means that it can withdraw that consent without detriment at any time in relation to specific processing. This means that you have to think about the actual relationship and the circumstances to determine whether in fact that choice exists and whether that withdrawal of consent actually can happen in practice. The GDPR itself recognises that certain relationships don't lend themselves to free choice and control. In particular, the GDPR points out that consent cannot be freely given and won't provide a valid legal ground for processing where there is a clear imbalance of power between the subject of the information and the controller who's making the decisions about how and why that data is being processed. In particular, we can look also to guidance from the collected regulators of data protection, the Article 29 Working Party, who have issued a guidance on consent, and this highlights that the employee-employer relationship is a situation where this imbalance is very likely to occur. In fact, the guidance goes on to say that it deems it problematic for employers to process personal data of current or future employees on the basis of consent, as it's unlikely to be freely given. So for the majority of data processing at work, the lawful basis cannot and should not be consent of employees. In practice, another reason for this is that employees, if you think about this imbalance point, they may feel under pressure to consent to widget retail's processing notices, particularly if they don't want to look like troublemakers in the eyes of their employer. So they might consent to anything if they know that it's tied to their payroll and to their salary. So consent is not going to be a useful basis here for widget to rely upon. Other points to think about here as well around these different facets of a valid consent is that consent also needs to be specific. In other words, it needs to be specific to the actual purpose. And another potential issue here with the approach that widget have traditionally taken is that they've sought to bundle a kind of broad range of uses of employee data under their employment contract. And whilst it might be appropriate under the contract to perhaps provide for processing of salary information as a sort of a necessary purpose. It's clearly not going to cover the wide range of operations that will not all be directly necessary for the purposes of fulfilling that employment contract. In addition, Widget has also, although we've already discounted consent here, it's worth pointing out that it has also tried to sort of conflate many different purposes under a single consent. So, notwithstanding that consent isn't relevant to the proposed processing, even in those cases where a consent can genuinely be relevant, it needs to be specific to the individual purpose, and not tied up under some sort of catch-all consent.
So as an operations manager, I really have to rethink my approach towards consent. I mean, it started with the view that we have consent. We've always had consent, and therefore, with that consent, we're bulletproof. But from what you've described and the way that GDPR applies, not only am I not bulletproof, but actually consent isn't even the silver bullet towards legitimizing that processing. So what can I do to move forward from that? And you mentioned a range of options, but can I not just change the employee notices, for example, to say we will rely on one of the other grounds, for example, legitimate interest?
Yes, I mean, I think the key thing here, though, is you need to look at each of the purposes that the employee data is being processed for, and establish and document the lawful grounds under the GDPR that's relevant to each of those. So again, even if you sort of said all of our processing is for the purposes of legitimate interest, again, that would not be specific to purpose. Now, it may be that there are a number of purposes that can rely on legitimate interests, but you need to consider each purpose and actually work out which is relevant to that processing. For example, there may also be legal reasons, legal obligations for processing certain data. There may be even specific circumstances where consent is workable. Let's say there was a scheme that the company was offering its employees, that they had complete and utter choice as to whether or not they wanted to take part in that particular scheme. It was perhaps a club, for example, that was open to employees to join, and perhaps might require some level of personal information to be provided, but it was entirely at the choice of the employee whether they chose to join that club. Then consent might be relevant in that limited set of circumstances. But the key thing here is to look at each of the purposes for which that processing is taking place, and to look at actually replacing kind of a broad and sweeping consent from the employee processing contract, and look instead to provide more broader information about the actual grounds that are being relied upon for each of the purposes by way of a notice to employees, for example. So,
with my operations hat on, it seems to me that consent isn't something that I should rule out altogether. That there are perhaps areas, as you described, that consent still has a role to play, and HR is just part of my remit. I also have to look after how we trade in our customer terms. So surely where we've collected customer consent in our terms, and where we've explained that we do things with data like credit checks, or to manage the customer's account, or even send further offers. Now, we're not talking about employees now, so I see how some of those issues around imbalance of power, etc., may not be relevant here. So I'm assuming that consent is going to be fine in this context.
As before, again, we need to look at the actual lawful grounds for processing, so they need to be specific to the particular processing. And omnibus consents are going to lack that kind of necessary granularity that we need. Importantly, where we're looking at customer data, we need to again move away from tying consent into acceptance of the conditions of the contract. So for example, consent's not going to be freely given where the performance of widgets retail terms are conditional on consenting to the use of data for purposes that aren't necessary for that contract. So an example in that case might be marketing, for example. Marketing is not necessary for the purposes of the contract, so to try and tie it into an all bundled consent under the terms would not work. Again, consent isn't going to be relevant across a range of purposes that customer data are being used for, and there will be alternative and potentially quite more straightforward grounds that could be available here. So to suggest that the processing must happen on the basis of a customer's consent would actually create some false expectations on the part of the customers and would be also misleading. Where consent is required, then it needs to be specific. So again, it would either need to be specifically set out within the contract and positive action taken in relation to that, or actually separated out from the contract. So, for example, in relation to marketing, marketing consents might be collected at the actual point of the information being collected, rather than as a check this box to consent to the terms and conditions, which would also cover marketing, which wouldn't be sufficient. So, in terms of revisiting consents from a kind of commercial terms point of view, in addition to identifying all of those different purposes and documenting the lawful grounds relevant to each, there's also a need, as I say, to take marketing consent out of customer terms and seek consent for marketing at the point they submit their details, and split those consents out into separate channels so that people are specifically opting in to different, whether it's widget's own marketing or whether it's marketing from other widget group companies. They should be separately consented to where that consent's required. Where consent is being relied upon, and which might be relevant in the case of marketing, then there should be clear information provided about how people can withdraw that consent as well. So that information should be presented clearly and in a way that is easily accessible and capable of being used. It may be also, because one of the elements of a consent is that the consent must be informed, that might also mean having to review and update privacy policies that are provided alongside mechanisms that are collecting consents, for example. So this would include providing details of each of the separate purposes of the processing of that customer data, for example, and the legal basis relied upon as part of that broader obligation to be transparent in order to collect, and particularly when you're relying on a consent, which would mean that that consent was more informed. And again, that privacy policy would need to be clear and accessible to customers. And finally, where you are relying on consent, where you can rely on consent, where consent is relevant to processing, there may be a need to revisit that consent to ensure that from a GDPR standpoint, you can actually demonstrate that you're meeting each of those different facets, those elements that make a valid and required consent.
Thank you very much, Sally. And I think from the key features that you summarised towards the end in particular, it really hammers home the importance of having a better understanding of your data, having a better understanding of the basis on which you are legitimising your processing of the data. And of course there is a difference in terms of how you legitimise your processing under the GDPR compared to the current data protection regime. And a lot of what you talked to explains some of the nuances there around how consent perhaps has a very different role to play under the GDPR, but also really, I think, highlights the point that you've really got to get to grips with understanding your data, understanding the purposes for which you process it, and then forming the view on what your legitimising basis is going to be under the GDPR. So the concept of GDPR audits, therefore, have quite a hugely important role to play as far as GDPR compliance is concerned and your readiness is concerned. And that's really what we want to move on to in terms of the second case study that we want to look at today. So the case study that we wanted to just go through with you today, coming up with a scenario that perhaps is not too unreal, and we certainly see these sorts of different features appearing almost every day in the advisory work that we are doing. But take for a moment, if I was to elevate myself to the dizzy heights of being the European General Counsel of a company called Infoglobe. The CEO of Infoglobe is getting rather worried about those big GDPR fines she's been hearing about. And she's asked me to do a quick assessment and then put in place whatever Infoglobe needs to do to avoid those nasty big fines. What are the key facts about Infoglobe in terms of the company and its presence and its size, etc.? Let me just give you a few features of that here. Infoglobe, it's a US company providing online weather forecasting and climate-related information. Clients that it has are mostly big corporates, shipping, insurance, and agricultural companies, those that rely on that sort of data input for their everyday business activities. Infoglobe for You is Infoglobe's only consumer-facing service. It's widely used in Europe and Asia, but barely profitable. So obviously there'll be some strains around any expenditure in relation to that particular business. In terms of global reach, employees and businesses around the world are all caught by Infoglobe's reach. It has a HQ in Europe, and that is in the UK. Now, by and large, and not unusual, it is a SaaS-based business. So, for example, insurance companies can load individual quotes onto Infoglobe's Climate Sure platform to calculate how long-range weather forecasts might impact on the price of insurance. So it really does integrate into the client and the way in which the client provides, runs, services its specific products. There is an element of outsourcing too. Infoglobe has completed an extensive outsourcing program and now has 2 centralized data hubs that are, as you would fully expect, cloud-based. So a lot to take on board, and bearing in mind the very clear instructions that we need to do a quick assessment, then put into place whatever Infoglobe needs to do to avoid those fines, which is not unrealistic of the words that we often hear from CEOs today. But we haven't got a lot of time until May the 25th. So, Jane, I'm thinking, should I just dive in and get going and see what happens, or is there another more strategic approach, I should say?
Well, Vin, I think you can just dive in, but you would be losing probably your one big opportunity to set this project up in the right way. And this is going to be a really significant project. I think you're going to have to, early on, you're going to have to disabuse your CEO that this is going to be a quick and dirty assessment. So I would take this moment when the risk and the visibility of this project is at its height and get what you need. So you're going to need some budget. You don't know yet how much it's going to cost to put things right, but you can at least get a scope for getting some external resource, for doing the initial assessments, and just give some idea about overall costs. It's a big and complicated business. You're one lawyer, and you don't want to waste your time on project management, so I would draft in some project management support, help you set up meetings to report out. You cannot do this by yourself. You absolutely need a commitment from each of the business and functional heads to work on this. And I would probably ask for a point person in each of the businesses and each of the functions who are actually going to be responsible for helping you drive this project through. You're going to have to somehow overcome maybe some politics, maybe some resistance within the company to this project. Particularly as you perhaps get outside the UK and Europe, where it's seen as so significant. And if you can get a really heavyweight senior executive involved, I think that will make your life very much easier. And you might also want to think about getting a steering group there, so that you're not taking all the big decisions yourself, that the decisions about your risk appetite, do you use external lawyers and consultancies, and how do you manage this project is actually shared across senior executives. Next slide. While I think at this point as well, just before you get going, I would ensure that you have a really clear narrative. What is this project about? What is it going to achieve? You've got, I don't even want to think of the number of working days we've got left until May the 25th, but it's not a lot. So I would really start to manage expectations now about what you can get achieved by then and what's going to take you probably until the rest of the year, possibly even beyond that. And find some way of reporting progress, either a dashboard or a weekly report or a weekly call, so that you can keep the confidence of all of your stakeholders and ensure that everybody knows where you are and where you're going, and if there are bumps in the road, what's holding you back.
Okay, so that helps me get off square one. And if I do that successfully, and I've got the budget, I have the senior executive and project management support that I need, all the stakeholders are on my side, so it's a winning formula. But what's the next sort of tangible steps that I need to start to take?
Okay, I think that the classic next step, and I think you have to do this, is some sort of assessment. And because as we were talking about before, you've really got to work out the sort of where, what, and when of the data. What personal data are you collecting? Where is it? Where is it being moved around? How is it used? What are you using it for? What's the legal basis you're relying on? And in order to do that, you've got to do an assessment, I think, of all of Infoglobe's products and services, and also all of its internal processes, for example, as we just spoke about HR, and all your arrangements with third parties. So the classic thing to do is to kick off with a questionnaire. There are lots of templates for these questionnaires, but the key thing is to make it easy to answer. It should be as simple as it can be, and if you can make it in the language that this particular business speaks, it will be so much easier to do it. Make it relevant, so make sure that you allocate the right questions to the right people. If your software developers see a bunch of HR questions, they're going to give up before they even get started. I would make individuals accountable, so make one person in each business and each function accountable for getting all the answers to you. And then you're going to need some time, because the answers that you get won't give you enough information. You're going to have to probably go back, ask a bit further, dig a little deeper. And so you need some time just to have those one-on-one conversations to make sure that you really do understand the where, what, and what for of data.
So that all sounds very clear, and I can see why we need to complete that assessment. But here's my worry. With the 25th of May deadline just so close, and despite the fact that we have buy-in for this assessment, and knowing my senior management team as I do, I'm concerned that the senior management team are going to start to get very nervous that here I am just going out doing an assessment, asking lots of questions, but in reality looking as if I'm not actually getting anything really done.
Yeah, if you go on to the next slide, I think this is very tough, and I think for anybody who is kicking off a GDPR project at this point, you really are going to have to prioritise very, very hard at this point. I think absolutely at the centre of any GDPR project is in fact the individual whose data you're collecting, and it's kind of easy to, in the morass of information and regulation and legal advice, it's easy to overlook that. But it's actually the individual that matters, and that's what the regulator will be looking at. So you need to prioritise by the interest of the individuals whose data you're holding. I would then look at the risk to your business. Are there any areas which are kind of built on personal data which are critical to you? So something like our Climate Sure platform is absolutely key to the business, and a lot of personal data will be running through that. And it's where all your revenue is based. So I would look at that. But there may be other areas, and I think Infoglobe for you is a really good example of small, neglected businesses can often carry the biggest risks. The revenue doesn't necessarily equate to the level of risk you're taking. And then I would look at risk to your timelines. There are some things that are just going to take a very long time to implement. For example, putting in place all your agreements with your third-party suppliers. Or if you know that you're going to have to make changes to your software, then you've really got to get those changes in to your sort of development cycle or into your budget cycle, and those can have very long lead times. So look at those things first. Then I think as you run out your audit, you're probably going to have to try to run in parallel with some of the big, you probably know, because you are, I'm sure, a great general counsel, you know already what your big risks are. You know that it's climate sure. So you could start working on that right now. Get going with the DPIA, and we'll talk about that later in this session. Maybe start to put together a briefing for your clients about how you manage data across that platform, how you protect it and secure it. Get ready with some data processing agreement for clients these are sophisticated big clients, and they're going to ask for it. You might want to, if you've got more of a team, you might want to also simultaneously get into a deep dive in the infoglobe for new business as well, and particularly look there at the marketing and privacy statements. Meanwhile, if you've got a little bit more time, and we go on to the next slide, you can, I think somebody has got to start looking at those third-party suppliers, those big data hubs out in the cloud, and any other outsourcing that you've carried out. You are now under an obligation to make sure that their information security is GDPR compliant, and you're going to have to enter into data processing agreements. For some of those really major, particularly the major cloud providers, you may actually find that easier than you anticipated because they're already there for you. They will have put out all of that information for you, and they will have standard data processing agreements that you can enter into. Again, what may catch you out here are smaller suppliers who are processing data, who will be less mature and may not have that information security in place, and certainly won't be ready with a processing agreement, but actually might be handling really vital information. And then your last piece I think you've got to take a look at early on is information security and data export. So I would say information security, if it's not strong at the moment, will be at the heart of this. There's no point in putting everything else in place if then you lose the data. You're going to have to get to grips with your 72-hour breach reporting, and that means a whole process going right through InfoGlobe that you can find out where there are breaches. And there are sometimes, there's a lost laptop every day, and you're going to have to work through that and make sure that you can get to report within 72 hours and work out some kind of strategy for those transfers outside the EU. Other than that, you've got all the time in the world.
And at the risk of making it sound as if it's all plain sailing, it's not just the senior management I think they'll get nervous. I'm starting to get nervous. Got to complete all those parts of the project, and that's a huge undertaking, and that doesn't even cover the policy work, the changes that we'll need to paper and implementing those policies, the privacy notices, and you talked about privacy by design and default. Any suggestions as to how we start to sort of really strategize around the many aspects of this project?
Yeah, I think it's really difficult, and it's hard not to be like a rabbit in the headlights, particularly at this point, so close to May the 25th. I think it's absolutely key to really look at the biggest risks that we've talked about, and again go back to that the most substantial risk, which is the risk to the individual, and absolutely start there. You may have to accept that some of that sort of policy work may have to come later. You can't run this yourself, so you're going to have to get other people to be within the business to be accountable for some of these projects and some of these parts of the projects. But also, I would share the pain. I mean, you are part. One of the great things about the data protection community is it's very collaborative. It's not competitive, and therefore there will be a lot of people out there in other companies and who can share this pain with you and talk about how they're approaching it, and you can learn from.
Thank you very much for those insights, Jane. And I think alongside any project that involves compliance, that involves assessment, that involves a lot of different aspects, which will take up a lot of time, which will take up a lot of bandwidth. You can't ignore the business as usual. You can't ignore the BAU. And one aspect of BAU is certainly in terms of the potential to derail or perhaps take time away from a project, is dealing with HR data protection issues. And one of those thorny issues that we find more often than not is around challenges such as subject access requests, for example. So I think it's worth us taking a look at how some aspects of HR data may present challenges, and perhaps we can shed some light in terms of how we can deal with some of those as well. And let me just paint the following scenario, and then Steph Creed is going to help us with some of that light I promised we would shed. So take the following case study. You work in the HR department of Holborn Digital Supplies Limited, which is the company we are talking about today. A sales team leader, Rob, approaches you with the concerns that one of his team members, Tian, is, quote, fiddling expenses and sales figures, quote. Rob tells you that Tian is a practicing Ukrainian Catholic. I have no idea why he's decided to volunteer that, but then again, so many times we often wonder why more information than you actually need is ever volunteered to you. A former disciplinary investigation takes place, and you interview and take statements from a number of Tian's colleagues. Several raise concerns about Tian's conduct, including John, who tells you in confidence that he feels intimidated by Tian, and that Tian was aggressive towards him in the past when John asked him about his sales figures. As part of the disciplinary process, you obtain sales figures for Tian's clients and for other colleagues as a comparison. You have concerns about disclosing all of this to Tian. You make a decision as to what information to disclose to Tian as part of the disciplinary process, and send a copy of this to Tian together with an invitation to a formal disciplinary hearing. So lots going on here. Prior to the hearing, Tian has been signed off from work with a stress-related condition. While absent, he sends an email complaining that he is being targeted because of his race and religion, and submits a subject access request, specifically asking for a copy of the unredacted statements from colleagues collected during the investigation, sales figures of other staff, and a breakdown of sales figures and client data. The request also asks for all documents by which he is mentioned by name, and then any that refer specifically to his race and religion, and as well as the documentation that refers to complaints about Rob's management style. A week after you send the response to Tian's subject access request, you receive a complaint from Tian about the handling of the subject access request itself, and threatening to take civil action and to complain to the ICO. His complaint specifically asks for copies of WhatsApp communications between Rob, John, and another colleague, Bispy, using their company phones. So, an awful lot that has been captured by what I very simply described business as usual. But we have to consider that there are lots of different elements that are brought into the process when you're not only talking about HR data, but the scenario that we've just outlined. Steph, how would you start off by looking at some of those issues that this raises?
I think the scenario is deliberately sort of constructed that way because it is the type of thing that we see coming through. Again, sort of as Vince mentioned, the types of data you accidentally get told, someone finds out because they've had a cup of tea with, or just pass it on just because. And the crossover between employment and data protection law is a sensitive area, and employers are going to find themselves having to balance competing issues, both for the business and the individuals that are engaged. Sort of alongside that is that employment tribunals and civil courts are ever more aware of data protection issues, as are staff members themselves, and the law is currently moving in the direction of increasing protection for employees and staff members. So employers are going to need to be alert to data protection issues where they may come up, and then take steps to preempt and prepare for that in order to best position the business going forward. And it's worth noting that under the GDPR, for member states, there is considerable scope for introducing national and domestic legislation for some aspects of HR data. So you will need to take this into consideration, particularly if you're talking about an EU-wide or global workforce, as opposed to just being based in the UK. But in terms of sort of tackling this head on, you'll appreciate that you're going to have to consider the implications of employment law whilst keeping in mind your data protection obligations. So at the outset of the disciplinary process referred to in the scenario above, you've got to keep in mind the risks around the allegations made and how they were treated, and possible protected characteristics pertaining to Tian in this circumstance, as well as how do you manage his data and what do you give to him. So in the initial disciplinary documentation provided to Tian, employers required to provide sufficient information so that the employee can understand the charges against them. So this would include details of any allegations, although think about whether statements can be anonymised, for example, and whether any commercial information that isn't needed for the employee to understand the charges can be redacted. We've picked up sort of John's concerns in the scenario about how data is, sort of how Tian has reacted to it in the past, and you may want to consider health and safety obligations to other employees and your duty of care to them, given that concern about aggression and possible retaliation, which could be serious.
But given that you mentioned that in a broader context here, and particularly when you're dealing with the disciplinary itself, and there is a responsibility to provide documentation there already, but now we've got a subject access request. So does that mean we can avoid responding to the subject access request if some information has already been given to Tian?
It would be lovely if we could, but unfortunately, there isn't really a way to get around responding to a subject access request just because of the disciplinary process. If a request is manifestly unfounded or excessive, you could charge a fee or refuse to respond, but in line with the emphasis in the GDPR on transparency and accountability, you've got to be able to provide evidence as to how you reach that conclusion, and you've got to tell Tian as well about the possibility of complaining to the supervisory authority, so to the ICO, and taking legal proceedings. So it might be a slightly uncomfortable one to be telling Tian that actually we're not going to respond because it's completely unfounded and it's excessive, knowing that the ICO actually will take a very different view. You could withhold data if disclosing it would adversely affect the rights or freedoms of others. Again, that's quite a high threshold to get over, so it's probably not going to be relevant for a lot of the information we're talking about in this scenario with Tian. One that might well be more relevant is where if Tian has made the subject access request for the primary purpose of causing trouble and expense, or is insisting on information that doesn't have any conceivable value to him, you could rely on the doctrine of abuse of rights and refuse to respond. But all three of these sort of scenarios that I've just touched on are going to be things that you're going to have to think about seriously, evidence, and really be confident that actually you are in the right in asserting that position. Because the underlying obligation is you have to respond to that request, and it has to be done outside of and alongside any disciplinary proceedings. You can't use the disciplinary proceedings itself to avoid responding to a subject access request.
And everything you read about and look at and assess on the request itself just says that this is just too extensive. But how extensive in reality does your search actually need to be?
So your obligation with regards to searches remains pretty similar to the current requirements. Searches have to be proportionate, and as the employer, you're not required to do things that will be unreasonable or disproportionate as against the importance of providing the individual, Tian in this case, with access to his data. So you'll need to review your main servers. You may need to look at backed up data, deleted data, and data held in other systems. But if it's going to be far too difficult for you to find information, or the request is so broad that it's not actually clear where to start, you've just got to do enough to show that actually your request and your search was reasonable in the context of the request that's been made.
And so often, it certainly seems, certainly at face value, when you look at a subject access request, parts of it obviously, usually anyway, appear to be relevant, to quite clearly speak to a request around information that a person's entitled to. When you look at a fairly extensive request, what information here do you think Tian is really entitled to see?
What he is primarily entitled to see is his personal data. He's not actually entitled under the Data Protection Act and the data protection legislation that's coming in, is that he's not entitled to see anything that isn't personal data. That might be something that's relevant to the employment dispute, but that's not the subject of the subject access request. So in this scenario, TN was asked for, amongst other things, sales figures and client data and unredacted statements as well. Now, it's likely to include data that isn't personal data, and it may include data relating to others. So non-personal information falls outside of the scope of the subject access request, no obligation to disclose it here. Make sure that you identify data which relates to other individuals and doesn't relate in any way to the employee, so to TN. And again, you don't need to provide this, and you could redact, anonymise or pseudonymise it if you need to. If the personal data relates to TN, but it's also information relating to other individuals, unless that other individual has consented, you'll have to consider whether or not it's reasonable to disclose the information without their consent. Now, if it's not reasonable to do so, consider whether by redacting the information, and in particular the information that would identify that other individual, it would be possible to provide the employee, in this case TN, with at least some of the personal data source. If you are getting wide scope subject access requests, you can think about responding to the employee up front as well and asking them, as you would do in sort of under the current legislation, to either reduce, narrow or identify, at least give you a better guidance as to what they're really looking at. And that should be probably the first line of defence in terms of a response to a subject access request, particularly a broad one.
And in terms of dealing with a subject access request from a centralised perspective, it's quite easy to see how the points that you've mentioned speak quite clearly to firms' systems, the company systems and data that's held on it. But looking back at the request that TN has made, he also talks about text and WhatsApp messages. How would you suggest that they are dealt with?
This is a growing area of problems for employers, and we are seeing more of it coming through. As a general rule, text messages and other informal communications directly between devices, so not using an external app, meaning I'm leaving WhatsApp to one side for a minute, are likely to be disclosable, particularly where work devices are used. So as the employer, you should be looking at terms of use and any acceptable use policies as guidance here and tightening up that sort of wording if you're not happy with it as it is. Having said that, WhatsApp messages in particular pose a problem for employers, and it does go to a certain extent to text messages as well. Employees have a right to privacy and may have an expectation separately of privacy based on staff handbooks, terms of use and other employer communications. So you could find yourself as the employer in a position where you're required to provide these communications, but you can't actually obtain them without breaching your duties towards other employees. So it is a bit of a minefield. So where communications are made using personal devices, as the employer, you're unlikely to be able to retrieve or force employees to provide that data. And do note that WhatsApp is also an encrypted form of communication, which adds its own layer of problem. So where communications are made using work devices, the question arises as to whether the employer is the data controller or processor. Now, arguably not, but if you as the employer rely on or condone the use of these types of communications for work purposes, so actually you're quite happy for employees to communicate over WhatsApp to arrange rotas and things like that, or you know it happens and you don't stop it, you're likely to see more arguments requiring the disclosure of such communications, and of course it can all be given as evidence in litigation if it comes to that.
So clearly lots of different aspects to pull together, quite a lot of information to search and pull together, redaction and other aspects to consider. How quickly do we need to respond to TN?
Unfortunately, the period response for a subject access request has reduced to 1 month under the GDPR, and the sanctions have also correspondingly increased. So you will need to respond to TN's request swiftly, and at the least you'll almost certainly need to provide further detail as to the information held about him, the processing that's carried out, and you may need to provide further details about the period for which data is retained and information about his rights. So it is a broad response, and do bear in mind, as you mentioned, redaction you have to factor into there, identifying other people's information, all the things that we've touched on already. it's not just going to be a case of pulling everything out and sending it over. You want to be clear on what you're sending and whether it's relevant and whether it corresponds to the request that's made.
And in being clear on what we're sending, what is clear is we look at the sheer extent of data that's potentially caught within a subject access request, and that's where that sharp intake of breath arises when you think, wow, this is all information I need to disclose, and some of this, quite frankly, is problematic. Can I not give some of this more problematic data? Can I delete some of the problematic data?
I think again, we have seen a question asked, but the firm answer is absolutely not. Aside from any problems that might cause you with litigation and your obligations to a court or a tribunal, it's an offence under the GDPR for an employer or a person employed by an employer to alter or erase information with the intention of preventing disclosure. So not only do you need to be aware of this, but you need to make staff aware of this. We see it coming up with sort of that smoking gun email that a manager sends when they're incredibly frustrated with an employee, and it's the bit that people want to sort of bury. You really can't, under the data protection legislation, as well as, I say, anything in terms of what you wrote to a court.
And given earlier on that we talked so much about outsourcing and cloud and in other words, that broader environment and infrastructure where your data might be residing. So if some of this is in the hands of our data processors, does that mean we don't have to provide it?
Again, doesn't get you out of anything. You still have to provide it. It's the employer who is the data controller who is responsible for complying with this subject access request. And if you use a data processor, you have to ensure that you've got contractual arrangements in place to guarantee that requests are dealt with properly, irrespective of whether they're sent to you or to the data processor.
Okay. And so dealing with the actual subject access request and the complaint itself, what other words would you want to say to sort of conclude the key issues?
I think it's important if you do get someone complaining about a subject access request response, and you almost certainly will, it's important not to panic, but to respond promptly and to investigate the complaint appropriately, but also to document your investigation and your response. Use it as an opportunity to review the processes, search criteria, other key aspects of your initial response, and to consider whether you have a ground for complaint. It's as much for sort of you to identify where your risks are, as also to use it as an opportunity to try and correct things. And remember, though, that you're likely to be writing communications for TM that could be presented in evidence. So do always remember who your audience is. It isn't just him. It will potentially be a courtroom or someone else.
Thank you very much for that, Steph. Conscious that we've come up to the hour, but there's quite a lot that we do want to cover in this session, given the importance of the topic and the importance of the different areas that we're trying to cover today. So for those of you who do need to dial off, that's absolutely fine. The webinar recording will still be available, so you'll be able to access the remainder that we're still going to cover. So we will allow ourselves to go over the allotted time, knowing that you can still tune in and listen to the recording a little bit later. Because there's still one subject that we want to try and cover. And we've talked a lot about process, we've talked a lot about impact, and the concept of data protection impact assessments is one that's very much central to GDPR, particularly the world of accountability as it draws into us. So that's a topic that we want to look at next. And again, in the same style, we just want to try and explore this in the context of a case study, and maybe just set out a few facts for you before we dive into some of the constituent elements that are worth us flagging today. So the scenario that we wanted to paint for you here in terms of impact assessments in the GDPR is as follows. So my role here would be as the data protection officer of a global company, and in this case in the insurance sector. The context that we have here, that there's a global implementation of a revolutionary tool to track employees and their communications and movements and behavior. The purpose of the tool will be the assessment of employees' performance. And if we start to look at the functionalities of the tool, we start to see that there are some key elements that we should be taking note of. For example, the monitoring of employee communications, including emails and conference and video calls over its own network on a permanent basis, including comms received or sent via business or personal devices. The collection of information from entry and exit systems of the building, which uses fingerprint access to the premises. The tool is managed and accessed by individual contractors, and again, speaking to the outsourced and offshored world, are based in the Philippines. And where there's unusual activities that are detected, the tool will automatically create records and keep copies of the activity with the full details of the communications and the personal details of the employee. The information in that case will not be filtered in any way. There'll be data matching, the information collected with the data that will be shared by its benefit provider, including health-related data. The data storage and retention is going to be a challenge because information that's kept on the employee file for performance and disciplinary purposes will be there just in case and for that indefinite period of time. So, what are the action that's been taken so far? Well, the employees have not been informed about the tool. There's no security assessment of the tool that's taken place, nor on the individual contractors concerned. So the scenario is that there is a meeting to take place between the data protection officer and the HR director. And the inevitable question that always arises, where the data protection officer has to guide and advise the HR director, is being prepared for that question from the business, in this case from the HR director. Is there anything we should do before we implement this revolutionary tool? Jean-David, where would you start with all that?
Absolutely, Dean, and considering the functionalities and the scope of the tool, my initial thoughts are that some sort of privacy or security assessment or so-called data protection assessment, DPIA, may be required. And since we have completed a GDPR program, we have created a DPIA package which can be used where there are reasons to believe that a DPIA should be conducted. And before we discuss what the DPIA should look like, it's worth reminding ourselves that a DPIA is an accountability tool to help an organization identify the most effective way to comply with their protection obligations and meet individuals' expectation of privacy, and in this case, the employees. And a privacy assessment will be at the heart of a project involving high-risk data processing activities. And what we see actually is that businesses are not always clear as to when and how such assessments should be carried out, and often lack a clear process to run them effectively. 2 points to bear in mind here. One is, whose responsibility is it to carry out a DPIA? Well, the ultimate responsibility lies on the data controller, but if you were acting as a processor, you may be asked to help the controller to implement a DPIA. In this scenario, we are acting as a controller, so we have the ultimate responsibility to conduct a DPIA if needed. The second point to bear in mind is that failure to implement a DPIA may conduct to fines. And as you know, the fines under the GDPR are quite high. And the maximum sanction for failure to carry out a DPIA under the GDPR is a fine of the higher of 10 million euro or 2% of an organization's annual global turnover.
So, against the backdrop of that, it's clear, as you mentioned, that the DPIA is a package, but what does a package actually look like?
Well, as we have implemented the program, we have created a package for the DPO and different stakeholders to be prepared when a DPA should be carried out. So what we have in our package is one, an assessment checklist, and I come on to discuss the assessment checklist in more detail in a moment. We also need to have the criteria and methodology to implement the DPIA. You may be aware of it, but the French Data Protection Authority has published a software which may help you carry out a DPIA. In terms of methodology that you may use, the GDPR does not define what is meant by DPIA, but does set out minimum requirements, including one, a systematic description of the proposed processing, including the purposes and grounds of the processing. Two, an assessment of the necessity and proportionality of the processing in the context of the purposes. Three, an assessment of the risk to the rights and freedoms of individuals. And four, the measures taken to address those risks. The third element to include in your DPA package is a list of people that you will need to involve, and this list may depend on the scope of the project, but you need to be clear on who should be involved and involve the relevant stakeholders. There is no need to involve everybody on the planet or everybody in the company, but as long as you have one person identified for a specific area, then you will be able to contact that person. The fourth one will be to include and take into account the guidance which have been issued by your local supervisory authority or the Article 29 Working Party. And as a reminder, the Article 29 Working Party issued some guidance in April of last year and revised this guidance in October of last year as well. The last element to include in your DPIA package is a matrix which may help you mitigate the privacy risk to an acceptable level, because this is what a DPIA is about, trying to minimize all the risks that you have identified.
So I can see at this stage, having outlined everything that you have done, and a HR director, in fact any other person receiving that level of information will think, do we really need to carry out a DPIA? Does it really need to happen given the sort of activity and the product that we're talking about?
Absolutely. And the first question to ask ourselves is really to have a look at the GDPR test, which requires to conduct a DPIA where automated processing of personal data is conducted to profile, make predictions, or take measures or decisions based on information about individuals. The second criterion is where sensitive or so-called special categories of personal data, such as race, ethnic origin, religious belief, genetic data, biometric data, or information regarding criminal convictions are processed on a large scale. So this is a test which has been set out by the GDPR. And when you look at the scenario here, the planned HR tool takes almost all these boxes and will almost certainly present a high risk to individuals. Once the tool is very wide in its scope and the type of activities carried out include processing special categories of personal data, because biometric data is processed when collecting fingerprints. Two, the plan is to implement the tool globally to all employees, and therefore personal data will be processed on a large scale. The third element is that a systematic and extensive evaluation of personal aspects relating to the employees, which is based on automated processing and the potential evaluation and scoring of the employees, which is on profiling, is involved as well. And fourthly, the employees have not been informed at all, and although it's not a requirement under the DPI, under Article 35 of the GDPR. It is a transparency requirement that organizations have to comply with anyway.
So with all that in mind, how do we actually start the process of carrying out a data protection impact assessment? It just seems that there's still so much to be done. Surely there must be some way of carrying out perhaps a form of pre-screening or an initial assessment to work out whether or not we need a full data protection impact assessment.
Absolutely, and a DPIA requires a lot of time and involvement from the different stakeholders. And usually what we recommend is have an initial assessment in place, which should help you decide whether or not you need to do a full DPIA. And you will need to document the fact that you have considered the issue in detail. The way the assessment should be presented really is a short document that can be used by lawyers, the DPO, or the project manager, or the staff who are not necessarily experts in data protection. So it's really a set of questions that you need to set out, which are really clear and which will require or involve very clear answers. And on the basis of those answers, you should be able to tell whether you need to carry out a full DPIA.
And in terms of carrying out the DPIA, it looks as if we really don't have any choice. We've got to do it. It looks like a full data protection impact assessment DPIA is needed. So let's get moving on this. What are the key things I now need to really pull into place to carry out a full data protection impact assessment?
So there are several stages that need to be considered. And the first stage is really to identify the processing activities and the data flows and analyze the different risks. And when you identify those flows, you will need to know what type of data is collected, what type of data is stored, how the data is used, whether the data has been deleted or accessed. And to do that, you may be able to carry out a data mapping exercise as well to help you visualize those flows. The second point is really to involve the right stakeholders, which need to be involved at the outset of the DPIA lifecycle. It is key that the right stakeholders are involved and you don't come too late in the process as well.
So it sounds like there's a lot of risk involved. It sounds like there's a lot of measures that I'm going to have to put into place to make sure that this tool is data protection friendly, it's GDPR compliant. Can you give me an idea of what those mitigating and operationalizing measures that I need to take on board are?
Sure, and to be able to think about the measures that we want to implement to be able to minimize the risk, what we have done is that we have consulted internally and externally as well to allow people to highlight privacy risks based on their own areas of interest and expertise. And the outcome of the DPIA should include the measures, safeguards, and mechanisms envisaged for mitigating those risks. In terms of measures, what we will recommend in this scenario, we want to clarify and review the scope of the tool and discuss with the person who wants to implement the tool to know whether we can limit the scope at all. One of the questions to think about is, can we exempt personal communications from the monitoring? So we will understand that business communications may be caught, but maybe here one solution or one recommendation would be to exempt those personal communications from the monitoring. Another measure could be that the monitoring should not occur on an automated basis and introduce some sort of human intervention, whereby, for instance, your IT team may decide where an incident has been identified, who that incident should be escalated to, for instance. Another point is that we need to think about whether we need to prevent the use of information for performance evaluation purposes, just because the scope of the tool is so wide that we may not need to use the tool for that purpose. And other measures as well that could be implemented is also to think about a retention policy so that the data is not retained indefinitely. And of course, inform employees about the existence of the tool, why the business needs it, and how the tool will be used. So those are the kind of measures that we think we need to consider and discuss with the HR director, the DPO, and the relevant people involved in this project.
And often at that stage, David, I think we've all been in that position as privacy advisors, that the key stakeholder that we are walking through this journey, their eyes have already glazed over and they're thinking, please God, tell me that's it, there's nothing else. Or is there something else that we should be flagging at this stage as well with this sort of product or tool?
So there are other issues to consider. The first one is as Stephanie mentioned earlier, there will be specific rules around employment, and you will need to see whether your local supervisory authority have issued a list which will require a DPA to be implemented. It may be that you will have to consult as well with your supervisory authority, so you will need to think about that. It may be that in the countries where you are established, you have trade unions, and therefore you may have to consult with them or inform them of the tool. And if you need to do both, it may delay the implementation of the tool as well. What you really need to think about is really how you are going to use your DPI package in practice to make sure that the process is fully embedded into your privacy culture, into your processes, because you should not think about it as an administrative exercise that will take you time. It may take you time, but privacy comes first. As Steph said earlier, employees have an expectation of privacy, so it may take time at the beginning, but actually the time that you take to go through all the steps that we have presented to you today will save you a lot of time in the future and will ensure that the privacy of your employees is protected and respected as well.
Thank you very much, David. And I think it's just important to labour on that last point just a little bit more, because if we just focus on what's in the press at the moment, it's quite clear that the needle has certainly moved in terms of the importance of privacy rights coming first, and the importance of transparency coming first, and the importance of real clarity on what is happening with data, and perhaps the reliance, or in some cases over-reliance on an assumption that people would know what you were doing with the data, is a time where, or a period in time where perhaps the time is up on that sort of approach. So a lot there I think is absolutely key. There's also a lot that we have mentioned today, and we are coming towards the end of the webinar, and we've covered a lot, and there are plenty of you still attending and tuning in. So I thank you, and I'm grateful that you've done so. As there are still plenty of you, I do want to just still run the polling questions and see if you've still got the appetite, having been listening to us for an hour and 20 minutes, to answer some of those questions. And the questions we're posing, really just two, but again, I want to gauge where you and your companies are. And again, I'm just going to present aggregate views here to help us explore what that position looks like. So the first question is, will your company have completed its review of all areas where it previously relied on consent to assess, and whether you've assessed whether that remains the correct basis under GDPR? So if you completed that review and made that assessment of the correct basis under GDPR, and 3 clicks for us in terms of either it's a no or it's yes, and you would have done that by the 25th of May, or it's in progress, even though you won't get there before the 25th of May. The second question is just focusing on that thorn, the subject access requests, and whether you're feeling prepared to meet the new regime. And Steph talked through quite a few of the different issues that can hit home and how the disclosure can be so extensive. So in terms of subject access requests, are you prepared to meet the new regime? So again, yes, if you feel you are prepared by the 25th of May. No, if it's not a core priority for you at the moment, and we talked about the impact of priority in your GDPR program, or whether actually it's even another step removed from a core priority. You'll deal with subject access requests as and when they come in. Whilst we're just waiting for those results to come in, I'm just going to begin to wrap up. I know we've had a couple of questions through, but given the fact that we've already taken liberty of extending the time to make sure we cover all the content and case studies, we perhaps won't have time to address your questions today. So whilst we're just waiting for those results, and I think some of those are coming through now. So in terms of the first question, it looks as if a figure higher than I expected. Some 75% of you think that you will have made that assessment by the 25th of May and identified that correct basis. So I think that's quite encouraging. I don't think that figure would have been anywhere near that some months ago, maybe even as recent, more recent than that as well. But there's still a quarter of you, 25%, believe that, whilst it's in progress, it won't be completed before the end of May. But great to see that there is such progress there. Turning to the second question on subject access requests, again, we know that it's becoming more topical. We know it's becoming more and more of an item that's on your radar. But interesting from what you're voting today, some 50% of you think that it will be ready. You will be ready by the 25th of May for the new regime of subject access requests. A small proportion, 10%, think it's not core priority for you at the moment. And again, that's not something that we should be critiquing in any particular way. Priority is an important part of GDPR compliance, so that's how you assessed it. But still a fairly significant 40% of you will deal with subject access requests as and when they come in. So very much a split picture there in terms of readiness around subject access requests. So maybe that's a topic we'll continue to comment on in future, in terms of webinars, in terms of the content that we bring to you, in terms of the checklists and everything else that we are making available, or, as I mentioned, available to you on the Global Data Hub. So please do stay tuned for the content that we are bringing to you, and also invitations to webinars and events. For now, I want to thank my colleagues, Sally, Jane, Steph, and John David, for the preparation, the time they've put in to present against the case studies. Thank you very much for joining us today and allowing us just to provide this extended session. So from the team here at Taylor Wessing, thank you very much and goodbye.